This decision is by far the most difficult decision that a defendant facing criminal charges can face. And it may be the most difficult decision they'll ever face in their lives. But it's important that your attorney is experienced, knowledgeable, sympathetic. Hello again. This is Lana Manitta with Ross & Law Firm, and I'm going to talk to you today about when to plead and when to fight in federal criminal cases. Before we get started, remember to like and comment on this video and subscribe to our channel. We provide a host of videos providing education on a wide variety of topics arising in criminal defense. So this decision is by far the most difficult decision that a defendant facing criminal charges can face. And it may be the most difficult decision they'll ever face in their lives. And in federal cases, defendants often feel, and rightly so, as if they have been overcharged or are being over-prosecuted. And what do I mean by that? I mean, they feel like they've been charged with an offense that significantly exaggerates or expands their actual conduct into something, A, they don't believe they were doing, B, they never imagined they were doing, or C, they actually weren't doing. And I suppose to very, very, very much simplify things, the decision whether to plead or fight depends on which one of the three is the case for a particular defendant. Now, obviously, if we're talking about C, a defendant did not commit the acts of which they are accused, then they should not, and in fact cannot, plead guilty. Rule 11 of the Federal Rules of Criminal Procedure requires that a defendant entering a plea of guilty has to swear under oath that he or she is in fact guilty of that offense. I mean, I know that seems obvious, but I think we all know of the stories of people who said, well, I pled guilty because I had to. I didn't want to take the chance. I didn't want to take the chance of going to trial. But in fact, there is it's called a colloquy. It's a question and answer, back and forth between judge and defendant when a defendant is entering a plea that really delves into, in detail, what the defendant did. Often they're asked in their own words what they did. There's sometimes a statement of facts that has to be agreed upon. That's part of the plea agreement. And the question is asked, are you pleading guilty because you are in fact guilty of this offense? And so, it's just simply not possible, not permitted, without committing perjury, to plead to something that you didn't do. So if somebody didn't do it, they can't swear that they did. Now, then we have the other category of folks who did commit the conduct that is alleged, but they never imagined while they were doing it that it constituted such a serious offense, a federal offense. And this happens most often when a person is charged in a conspiracy and they find themselves being held responsible for the actions of other people, perhaps people they didn't even know in the indictment, and facing years of prison time for what they thought wasn't really a big deal. What they were doing didn't seem that big. So perhaps this is someone who benefited in a very small way from a larger fraud scheme, or they participated in a few drug transactions with a friend, or in, the worst case, they were present when a violent offense was taking place and they were the lookout. They were 2 blocks away, making sure nobody came down the street. Maybe they even, refused to physically participate in the actual violence, a robbery, an assault, or even a murder. Now, these folks, would usually do well, assuming that the government has the evidence to prove the conduct, to try and reach an agreed resolution with the government that includes stipulations that limit their involvement to the facts of what they've actually done, and therefore limits their sentencing exposure. In other words, cabining the liability, the exposure, the facts that they're agreeing to what they actually did. Because otherwise, if they go to trial on the position that, well, I only did that little part of this big thing, so I'm gonna fight. Unfortunately, under the laws of conspiracy or aiding and abetting, for instance, the defendant is going to face liability and responsibility for acts of co-conspirators or co-defendants that they knew were happening or that were reasonably foreseeable to them. And this can result in somebody doing a very small thing and facing a mandatory minimum or enhancements on their sentence for acts that were taken by co-conspirators and not even by them. So in a case like that, we're often looking to reach a resolution that's going to, lessen the exposure and keep the facts to the facts that only involve the conduct of the particular defendant. Now, the more difficult decision is for the person who falls into category A. That's the person who doesn't believe they committed an offense at all, either because they didn't intend to, or they shielded themselves or thought they shielded themselves from criminal behavior that was going on around them. Maybe they thought they were maintaining some sort of blissful ignorance about the true depth or breadth of what was really going on. Now, why this is a difficult decision for this particular type of defendant is because they really need to be told what they need to hear, not what they want to hear, right? If the evidence is there that the conduct that is alleged was committed by this defendant, and that conduct does rise to the level of meeting the elements of an offense, just because they didn't mean to or thought they were protecting themselves from, maybe taking that extra step into committing an offense, just because they didn't mean to doesn't mean they didn't. And that is often the client or the defendant that really has the hardest time sort of coming to terms with what is the best way for me to handle my case. And this is where, experienced, knowledgeable, and sympathetic criminal defense counsel is really necessary, because this is a frustration point for the client, and this is a difficult road to navigate. So if the evidence is there, and again, for example, there are crimes for which intent is not an element, or you can be bound to having intended to do something by making yourself willfully ignorant of what was going on. I purposely didn't ask them what was in that package that they asked me to deliver and paid me $5,000 to deliver across town. Well, that's called willful ignorance. If you purposely avoid knowing all of the details, but you still undertake all of the elements, your conduct still undertakes all of the elements of an offense, your willful ignorance is your intent. It satisfies that element, okay? And so in this type of situation where you have someone who thought they were protecting themselves but really didn't protect themselves, they really did step in it, as the case may be, then counsel should be looking to find a resolution short of trial for that client. Or else it's going to be a very rude awakening at trial when a jury renders a verdict. And that rude awakening really should take place in the attorney's office, not in the courtroom. Sometimes there's nothing that can be done. It is a client's decision. If they want to go to trial, I'm going to trial, and I'm going to fight. I'm going to fight hard at that trial. But if I haven't told my client ahead of time, well ahead of time, what is likely to happen at trial, what is available as a potential resolution, and why I think that might be a better shot for them, then I really haven't done my job, right? I mean, that's something that really should be on the table really early before a client's making this difficult decision. So in any of the cases that I've talked about, any of these categories, aside from the defendant who didn't commit the offense, there is an additional consideration. And maybe even for the person who didn't commit the offense, but largely this comes into play when someone either, didn't think they were committing the offense or didn't believe, still doesn't believe they committed an offense, but criminal behavior was going on somewhere around them in their vicinity, let's say. That defendant may have information about this offense or other offenses that might be helpful to the government in investigating or prosecuting a crime. And if the client or the defendant is willing to share that information, then pleading guilty might be a good option, because that might be the only way they can do this, the only way they can share that information for a benefit. The government will take information from somebody anytime, but the only time it can be through formal cooperation from which a benefit can be gleaned by the defendant is usually in a plea agreement, or a plea agreement that has an attendant cooperation agreement, a separate document that might be filed under seal, for instance. Cooperation that rises to the level of substantial assistance, it's called, that can be grounds for a very significant reduction of a sentence. And that's a motion that only the government can file. And that's why it's usually part of a plea agreement. They're not going to let somebody go to trial, challenge the case, fight them for months or weeks on end at trial, lose, and then say, okay, now I really would like to help you and get my sentence cut. The government isn't going to go for that. In extraordinarily rare situations that are really too narrow and infrequent almost to even mention, someone who's convicted at a trial might later have useful information, usually on other crimes, that the government might come and speak with them and move for a reduction of their sentence. But it's so extraordinarily rare that if a client or a defendant thinks that they have information that they want to share to help themselves, they need to be doing that on the front end. That needs to be talked about with the government early on, part of a plea resolution, and done, as early and as often as possible, I like to say, because otherwise that door to cooperation is going to close and it's not going to reopen again. Now, if you have a situation where your client doesn't want to cooperate, which is common, or because what the government is offering is a mandatory minimum that the client is going to get anyway if they go to trial, or might get anyway, or you've got a pretty good chance of getting for them anyway, then, a defendant is going to choose to go to trial, even when the government's case is strong, because they, will want to take a shot at winning. There's confidence in the counsel's ability to challenge the evidence. They may, on principle, feel that they are simply not going to admit guilt. Again, if they're still in that category A, where they just really don't feel or believe that what they've done violated the law. Or in some cases, if the offer from the government is not a good offer, it's not a bad idea to let the court hear the whole story through trial, rather than as a condensed snapshot at sentencing or at a plea hearing. Because again, with a plea, there's an agreed upon set of facts. The government wants you to say you did what they say you did. And they're going to condense it down into, an unfavorable version. And you're largely expected to agree with it. Now, you can come to the sentencing hearing and offer mitigation and, sort of blur the edges of that agreed statement of facts. But if you backpedal on any of it, you're violating your plea agreement. So sometimes there simply isn't a way, and I'm actually in this situation in a couple of cases right now, there isn't really a way to reach an agreement with the government where we can find facts that we both agree on. maybe the defendant is willing to say, yes, you know what, I did involve myself in this, but nowhere near the way the government says I did. And the government is saying, well, if you don't agree the way you did it the way we say you did it, then we don't have an agreement. Well, what are you going to do? You have two options. You can plead straight up to the indictment, which then you're agreeing that everything in the indictment is correct, or you can go to trial. And by going to trial and knowing that ultimately there may be a guilty verdict, but being able to let the judge hear the whole story and where the actual challenge lies, what facts, is it the level of involvement that you're challenging? Does the government have it wrong about your client? Then this might be the only way really to present that case fully to the judge. And that's going to help later at sentencing. So there's so much more that I could say on this topic of when to fight and when to plead. And I mean, it is a case by case, client by client analysis. There's, factors involving risk aversion, family responsibilities, all sorts of considerations that come into play. So there's no formula for making this decision for any one person, but it's important that your attorney is experienced, knowledgeable, sympathetic to the difficulty that faces, that a client is facing making this decision, and can really help you and guide you. I mean, they have to be a guide. They can't make this decision for you. They have to guide you through, what's going to happen if we go down this road, what's going to happen if we go down that road. If I do my best on both roads, here's what I think is going to happen. Here's the worst case. Here's the best case. And ultimately, giving all of the information necessary to make a decision that you can live with and be comfortable with is what counsel should be doing. So that's what I have to say today about that difficult decision. Remember to like this video, comment on it. Let us know what else you'd like to hear about in the area of federal criminal defense or state criminal defense, especially in South Florida, where Rawson Law Firm practices, and subscribe to our channel. And if you or anyone you know is facing criminal charges in the state courts of South Florida or the federal courts, anywhere in the United States, please contact Rawson Law Firm today. And thank you for watching.